Hello, good evening. Can anybody hear me? Please, if you can hear me, please unmute your microphone and tell me so I'll know if I'm being heard.
Yes, we can hear you.
Okay, we are just going to wait for like a minute or two. Want to see if other people will join and we'll begin immediately after that. Okay, we are going to start now because we already have our mentor here and it will not be right for me to keep her waiting. So, good evening, everybody. My name is Ede Emanuela and I'm going to be the moderator for this session today. And firstly, I would like to start by asking every one of us to please turn on our cameras so we can take the screenshots now because it's going to get late soon. So please, you can mentally please turn on your cameras and our mentors, if you can also turn on your cameras, we really appreciate it.
Good evening, everyone. Please, can we have our videos turned on so that we can take a quick screenshot? If that would be possible, we would really appreciate. Right. So, because of the lightning, we don't want the place to be very dark before we take our pictures. So, please, if you can, kindly turn on your video. Thank you.
Okay, thank you very much. Thank you. So please, I would like to start by first introducing our mentors for the day. I've been privileged enough to go through their profiles beforehand, and I would like to tell you that the mentors for today are going to be people that you want to make sure you take your notes, you learn from them because those people are very qualified and have a lot of things to say in regards to the topic for today. So I would like to start from our first mentor, who is already on the call, in the person of Mrs. Amanda or Miss Amanda Uzaba Esquire. So Amanda Norma Uzaba is an entertainment lawyer, an award-winning author, an entertainment executive and consultant, a public speaker and a legal educator. She holds a law degree from the Nigerian University in Nsukka and was called to the bar in 2017. She's currently the head of licensing West Africa at Ndundo.com, a Pan-African music service company, where she oversees licensing operations within West Africa, particularly Ghana and Nigeria. Amanda has facilitated many events, conferences, and webinars targeted at educating and entertainers, entrepreneurs, and creatives on the protection of their intellectual property rights work. She has more than 8 years of experience in the entertainment industry, starting as a blogger and a PR consultant for record labels before she was called to the Nigerian bar. As an entertainment business executive, She has facilitated and negotiated over $5 million involving catalog sales, endorsement deals, branding, licensing, distribution, publishing, and deal recording deals, live events, and so on for an array of artists, record labels, and investors, as well as helping them navigate the complex legal landscape of the music business. She has also worked on more than 45 productions exhibited in theaters, film festivals, and on international streaming platforms. She has also worked on a variety of co-production, development, and production deals with international studios such as Netflix, Sony Pictures, BBC, Westbrook, AMC, Amazon Prime, Green Door Productions, etc. In 2019, Amanda launched her consultancy firm called Gold Risk Consult, a boutique consulting firm that focuses on the entertainment and creative business, providing a range of services related to the legal and business aspects of the entertainment industry. Her diverse background and extensive experience makes her a prominent figure in the intersection of law and the entertainment industry in Nigeria and across the world. Please welcome our first mentor, Ms. Amanda, and I'll go on to read the profile of our second mentor now, Rita Anwiri Chinda, and she's on call now. So Rita Anwiri Chinda is a distinguished lecturer at Rivers University and an expert in intellectual property consulting. She currently serves as an IT consultant for IGA Nigeria Limited, providing valuable guidance on commercializing and monetizing Lagos State culture, tourism, and heritage. In her role as a heritage consultant for the Lagos State government, she offers legal advice on leveraging the state's intangible assets. Rita holds a master's degree in intellectual property and information technology, which she earned with honors from the University of Derby in the United Kingdom. She is also the host of the only sub-Saharan and popular podcast called IP Series, where she engages in insightful discussions on the latest IP issues and developments worldwide. The podcast has garnered a significant following, with 128 episodes published on Spotify for podcasters, Spotify, Apple Podcasts, Amazon Music, YouTube, and other platforms. Additionally, she has authored 25 blog posts and continues to produce engaging content on Substack. Throughout her career, Rita has actively contributed to various organizations and initiatives. Notably, she played a vital role in drafting the Rivers State ICT policy as a valued member of the team. She has also served as a judge for the prestigious Adavisa Lao essay competition on privacy data protection for 5 consecutive years, from 2019 to 2023. Recognized for her expertise, she was recently featured on BBC Nigeria's program on Channel TV. Rita is currently a member of the Technical Working Group responsible for drafting Nigeria's geographical indication law. This initiative is carried out in collaboration with the African Intellectual Property Rights and Innovation in Africa, an Africa convener of the Intellectual Property Society of Nigeria. An Africa International Trade and Commerce, with support from the European Union, EU. As the chief convener of the Intellectual Property Society of Nigeria, IPSN, alongside her team, they have successfully organized 2 virtual conferences that have taken place so far and celebrated 2 World Intellectual Property Days. Presently, she is the second vice chair of the MBA section on Business Law, Sports Entertainment and Media Committee. IPLAN has named her as one of the top 20 women in IP in 2023. In 2022, she received the award for Technology and Innovation in Law at the 4th anniversary of the Young Legal Professionals, YLP. This award honors the group member who has best displayed exceptional skills and talent in technology and developing fields of law. Some of her other career highlights include a member of the Global Steering Committee of the Chartered Institute of Arbitrators, CIARB, Young Members Group, YMG. She won the Esquire ESQ Nigeria Legal Award for 40 under 40, the 10th Secretary of the Chartered Institute of Arbitrators, Port Harcourt, chapter's Young Members Group. She's listed as one of the leading Nigerian women in business law in the inaugural edition of the ESQ Legal Practice Magazine 2020, the WIPR Influential Woman in IP Trailblazer, and she has been featured in the inaugural edition of the All Things IP Africa Magazine of 2021, the Young Legal Professionals Award of Excellence recipient. She's the legal advisor to the Rivers State Musicians Guild, the chartered president of the Rotary Club of Port Harcourt Greenbelt. She's an adept public speaker and educator. Rita has spoken at many events, both physically and virtually, to raise awareness and educate students, co-workers, creatives, innovators, and sectors that interact with intellectual property. She enjoys traveling, watching South Korean films and television shows, listening to music, and she adores dogs. So I'll read the profile of our third mentor now. Mr. Tope Salami. Tope Salami is a legal practitioner of international repute and an ECOWAS youth ambassador who has been in the core practice of intellectual property / technology, media and entertainment law, general litigation, and corporate and commercial transactions since being called to the Nigerian Bar Association in November of 2014. He has advised numerous individual clients, brands, and corporate agencies across numerous countries in different continents on different aspects of the law, brokering multi-million dollar deals and forming relationships with top brands executives on a personal and working relationship. He's the founder of Whitestone Solicitors and Consultants. Provides various and consultancy to people in different spheres of law as legal advisor against musician Barry J in Ghana. He led a team to successfully negotiate various deals involving numerous clients. Involving He led a team to successfully negotiate various deals involving numerous clients with Universal Music Group, Empower, Sony, and SACEM. He has also been recognized by
Sorry, please, can we hear Emanuela, or is it just me?
No, we can't hear her.
I'm sorry, you think logged out. I think that's the network. I'm sorry, can I be heard now?
Yes, we can hear you now.
Okay, I think that was a network error on my part. I'm very sorry to our mentees and mentors for that. It was network error. He has over the years numerous speaking engagements within and outside his country of residence, from speaking at the Young Entrepreneurs Entertainment Conference in Accra, Ghana, to being invited to speak at the Medium Conference at Paris, France, and more recently at the Intellectual Property Conference at the Ekiti State University, Ekiti, Nigeria, etc. Over the past years, Dr. Salami has been drawn to the Nigerian creative space and has dedicated the last years to having a better creative space in Nigeria in terms of structured framework and legislation. Tope is a passionate engager in the field of technology and intellectual property, and to this end has graced various stages with other top world practitioners to share his experience within and beyond Africa. Thoughts and knowledge on this developing field, particularly in Nigeria. Further to his passion towards having a sane creative industry, he founded a Nigerian creative firm named the Creative Yard, which caters for the need of different creatives, as he holds the firm belief in the quote, talent is not sufficient to build a proper creative brand. Creative Yard's sole purpose is to nurture and guide creatives for sustainable growth and development in their chosen field. He currently stands behind heavyweights in the creative space, such as DJ Neptune, Blaze Beats, DYDX, etc. And from the profiles I've read, I know that you and I know as well that these mentors are not people to be trifled with. So please, I will ask that as the mentors begin their presentations now, that you take your time to listen and learn extensively from their wealth of knowledge. And please, our mentors have 15 to 20 minutes each for their lessons. And I'll humbly ask our mentors, please keep to the time so we can make sure that the mentees have time for their presentation and to also get feedback from your knowledge. Thank you. So I'll call on our first to start the lesson for today with Mrs. Rita or Miss Rita. I'm very sorry if I'm making a mistake as regards to that. But Miss Rita, please, I'll humbly ask that you start first. Thank you.
Hello everyone, good evening. I was expecting to start first, but it's fine. But it's a pleasure to speak to you all. As I introduce, my name is Rita, and I will be having like a brief summary of what the music business and the law entails. I believe as IP enthusiasts, you already know that um, music is one of the eligible IP works um, that enjoys protection under the Nigerian Copyright Act. And it was very important to also state that the musical work, as you know, and sound recording, which are eligible work, are two distinct um, types of a musical work, whereby you have the composition, which is the lyrics, and then the sound recording. And these two sets of music requires two different types of licenses. So basically, I'm just going to touch on the exclusive rights that the music and sound recording enjoys in terms of the bundle of rights as provided under the law, which are basically the right to publish, reproduce, communicate to the public by any wireless means, adaptation, translation. Then you also have the rights that performers or composers enjoy, which includes monetary compensation to um, register or get royalties and be properly remunerated in terms of licensing and assignments. Then you also have the right to prevent any distortion or mutilation of a musical work or a sound recording, which is also known as the moral right. So you can see section 15 for the principle on remuneration, which is also an economic right, and then section 14 for what the law provides in terms of moral rights. Interestingly, under the old act, moral rights wasn't clearly stated. However, under the new, yeah, however, under the new law, you can not assign your moral rights. In the event where you do so, the law cannot protect you, because if you sign a contract, you're bound by whatever terms and conditions are in that contract. They also have the right to register your work with the Nigerian Copyright Commission, which you can find under Section 87. The law doesn't make it mandatory, but it's advisable that you document and deposit a copy with the Nigerian Copyright Commission so that in the event of a dispute, you can actually have some sort of proof of documentation where NCC will give you a certified copy to use in your documentary evidence. So see Section 87 for that. They also have the right to explore Section 90, which talks about resolving disputes in relation to licensing and royalties. So the NCC would set up a dispute resolution board that would take care of that. They have the right to also be affiliated with a collective bargaining organization, or you can create one that has to be transparent and accountable to you. So they can also help you basically track your revenues, especially in this digital era that we currently have. They have the right to seek redress and enforce your right in courts through civil remedies or criminal remedies. There's currently a criminal copyright case going on between MTN and NCC. So I'll advise you guys to follow it and be abreast with what's happening in the case. Then when I talk about challenges, you have digital and physical piracy, unauthorized use or alleged infringement or cross-border infringement in relation to the use of a musical work, whether it's a composition or sound recording. And we already know that, not assume, but when it comes to IP generally, when someone doesn't get consent, written consent, permission, authorization, which the Copyright Act provides that for a written exclusive license. For an exclusive license, basically must be written. For a non-exclusive license, you have the options of having a written license or through body language, through acts, whatever it is. So, but it's advisable that you have like a written and binding license. Have a binding license. Hold on. Yeah. Then talk about breach of contracts and restrictive clauses. You also have issues in relation to lack of transparency and accountability from the CMO. And I believe that for those who are interested in leading the music industry space, you should pay attention. I mean, you may have seen news as to the dispute that was ongoing between COSON and MCSN as to who should be the right CMO to collect royalties on behalf of musicians or artists. Currently, the Nigerian Copyright Commission had issued a statement, I think that was 2 years ago or last year, stating that COSON's license has been revoked. Not sure that has been updated, but that's like the last update I have in regards to that. They have issues as to, or challenges as to low payments, low per stream payment for artists in Nigeria. Then you have distribution and publishing options. In light of the digital era, we had disputes or conversations around use of AI tools in either imitating or creating musical work. And I think the most popular one would be the Drake music. And I think the recent diss that was ongoing between Kendrick Lamar and Drake and everyone that was in that drama. They also have circumvention of technological protection measures, whereby someone bypasses the protective measures that they are put in place to protect their musical work. So you can check out section 50 on that. It also makes provision as to how this can also aid infringement, such as hacking or decrypting or deactivating access to a musical work and then going ahead to upload it. I don't know how many of us recall when I think it was Beyonce when she released, I can't remember the album now, but I had to be uploaded and it had to be uploaded onto I'll come back to that. But then what I'm trying to make emphasis on is the fact that if someone takes the length to actually protect their work and you go ahead to bypass that or set up some sort of code to deactivate whatever encryption that has been put in place, the Nigerian Copyright Act now has a provision for that to protect all copyright work, inclusive of musical and sound recording. Then you also have issues or challenges as to royalty fraud, also known as the black box problem in relation to CMO collection and artists getting their royalties that they are due. They also have absence or disregard for a blacknet license, and there are conversations in relation to how radio stations are opposing having to pay a fee to actually use artists on, because the practice has been that some artists go ahead to pay money for promotion, and then the CMOs may having difficulty in terms of trying to enforce royalty payment for that. They have issues as to liability of internet service providers where um, an alleged infringer or someone keeps uploading a song that doesn't belong to them. So an artist or the copyright holder of the musical work or the sound recording has the right to um, write a letter to the internet service providers to take down that musical work or sound recording. So see section 54 to 62 of the Copyright Act to be properly guided. They have lack of effective collaborations within the sector. Then next is talking about the term of duration. So under the new act now, we now have like an expanded term of duration or length of protection for musical sound recording, whereby an anonymous work or a pseudonymous musical work can last for 70 years after the year in which the work was first published or made available to the public, but it must be with the consent of the author, or 70 years after the work was created. We already know that musical works last for 70 years, life plus 70 years after the author has died. For instance, you see the families of Michael Jackson and the fella are still benefiting from the term of duration that the musical workers that their I don't want to say ancestors that they actually created. Then sound recording is life plus 50 years. In an event where you have more than one contributor, it's going to be life plus the um, life plus then 70 years after the last contributor or author has died. Then regulatory framework in the Nigerian music business space, you have the CAMA 2020, the Partnership Law of Lagos, especially if you're dealing with record labels that are going into collaborations or partnership. You have the Copyright Act of 2022, you have the Business Facilitation Act, which amended a couple of laws in Nigeria, for instance, the Trademark Act, the Immigration Act as well. They have the Trademark Act, they have the National Broadcasting Commission Act, yeah, and the Broadcasting Code, they have labor laws, you have the Arbitration and Mediation Act in the event where parties who have entered into a binding agreement must have a dispute resolution clause, which would dictate how they can resolve any musical dispute. I know that I had previously mentioned that the NCC has a dispute resolution board. Now that would happen when a party doesn't have a DR clause and they choose to submit to an institution to help them resolve their dispute. For the NCC dispute resolution board, they already clearly stated that the kind of dispute they can handle is with regards to licensing and royalty dispute. I would like to mention the case of the late Onyeka Owena between IROC and TV, where she had gone into an agreement with them to use her musical work, and after the relationship had terminated, they continued using it. Unfortunately, she didn't get a good compensation, but like I always tell people that for you to actually get what you really want from the court, because the court is not Father Christmas, you have to carry out an IP valuation to determine what you would have earned during the timeline that unauthorized use took place. So IP audits, IP valuations, very important. And then there's contract law as well. The relevant agencies would be first would be the Nigerian Copyright Commission. Before we start talking about other institutions like the CMOs, then consider the National Film and Video Censor Board. Type of agreements, you have recording contract, producer and production agreements, collaboration agreements, release commitment, performance agreement, music distribution for digital distribution, music publishing, which is most times explored by independent artists. We have the split sheets agreement for songwriters. We also have merchandising agreements. You have branding, marketing, promotion, endorsement. Then other things to consider would be the finance and taxation. The Copyright Act has a provision on copyright levy, so please check that out. I also have a publication on that. Then there's the management, and then there's the A&R. So if you now want to go into that sector, you need to represent an artist or a songwriter or a composer or a producer. You need to come prepared. You need to also familiarize yourself with the clauses and what the person you are representing is actually looking out for. Ensure that you have a good negotiation power so you don't come out later to say that you are taken advantage of. Then be on the lookout for common pitfalls at the end of the day. So because I also do a bit of, not a bit, but because I'm an arbitrator and I'm also in the dispute resolution sector, I always like to talk about how creatives, and in this instance now we are focusing on the music space, what are the claims and defenses that one can, use as an argument to claim ownership in relation to a master recording. And at the top of the list is always fair dealing. So fair dealing for Nigeria, fair use for the United States. I see a lot of people always interchangeably use the word. So fair dealing would necessarily be used where someone is not commercializing a musical work or a sound recording. If you're not making money from it, it's for private use, you're listening to it. And I think the recent conversation that's been trending for a couple of weeks now that has a viral TikTok challenge in Bongo also, kind of raise issues as to people's knowledge in relation to the music space and what will qualify as fair dealing, what will qualify as copyright infringement, how the role that the DSPs plays, and several other conversations that were born out of that. Then if a work is in the public domain, so because I already talked about the length and duration or term of protection that a musical work enjoys, someone might come out to say that the musical work or the sound recording they are using has already gone into the public domain. Now understand that to a lay person, when you're talking about public domain, to their mind, what that means is as long as you've put the work in the public, it's not in the public domain. That's not how public domain works in relation to IP. Then another difference is that the user has a license or an assignment to use the work in question. Now, unlike trademark where non-use of a mark can lead to cancellation or your trademark to be revoked, in copyright, if you're not monetizing your work, you're not benefiting from it. Nobody's going to come and say, oh, because Anri's music or Anri's song recording is not being used by her, then NCC should revoke. NCC is not one that grants you automatic protection. It's the law, the backing of the law, which is the Copyright Act, that gives you that right. And because I would say generally or globally, a copyright work enjoys automatic protection. However, because IP is territorial in nature, every country is supposed to actually come up with their own copyright act. So in Nigeria, your work enjoys protection for the moment it's created. And the first person that creates the work, the authorship, and ownership vest with that person. In the instance where you have a contract, that will now determine who is regarded as the author and owner of the musical work. Then you have music clearance, which must be perfected. If it's not perfected or complied with, you're gonna have issues over that use. I think so. There's a conversation that was trending on Twitter a couple of weeks ago where an artist came out to say that he didn't get clearance to use someone's work and he actually featured Drake on that production. He actually had gone to get clearance, but the person refused, stating he had his personal reasons and principles. And then he comes on here to make a jest of it and say, "Oh, he's Christian and stuff like that," which is why he didn't use it. But whatever, we still went ahead to use it. But the update to that conversation now is that the said artist whose work was used has given them a condition as to how to use the work. Remember, I talked about moral right, where someone cannot distort or mutilate your work. You always have the final say as to how your musical work can be used. Then the user might claim that they use that they own the IP and they are the first owner of the work. For instance, would be the Mariah Carey, All I Want from Christmas Is You. I think every year she's always having someone coming up to say, "Oh, I'm the one that first sang the song, the title, All I Want for You for Christmas Is You." Then you also have CPA, which I always allude to, which is the concept permission authorization was obtained. And then another other conversation that I'd like to bring our attention to is the estate planning and succession for recording artists and sound recording and live cases. I'll start with the Nigerian ones, Fela, the Dagbin, and I would say the most recent one, which is the mobile case that has been, the conversation has been ongoing for a while now. Now, estate planning require that you prepare yourself for the unexpected. In the event where something happens, maybe you have an accident or you die. Sorry, hold on. What then happens to your successors in title? So ensure that if you are advising or working with a creative who's either a songwriter or an artist, that you advise them to first properly document um, their musical work and sound recording and clearly stated who owns what. So someone doesn't come out when something happens to say, "Oh, I actually own them," because there's no proof of documentation or IP registration. You now have this issue of going to court and trying to settle all of that. Then ensure that you advise and also help draft a will that outlines who gets the assets, who gets to enjoy the commercialization of that asset, um, for the length of time or time of duration that the work will last. So if it's a musical work, 70 years, if it's a sound recording, 50 years, if it's an anonymous work or a pseudonymous work that eventually gets published, timeline as well will also follow. They also get the right to control the bundle of exclusive rights and also any post-mortem image rights or right of publicity conversations that may be had. At the moment, we don't have like a clear legal framework in relation to image right or publicity right. However, it's kind of subsumed under some other legislations like the um, Data Protection Act for privacy and the Constitution, uh, Cybercrime Act as well. Then ensure that you carry out an IP audit and do an IP valuation to be sure of the value of the musical work, its catalog, and all of that. So someone doesn't come to you to make you an offer that you think is mouth-watering. Whereas if you had done an IP valuation, you would find out that it was worth more than what you were being offered. In relation to the role of DSPs, I won't talk much about it because we have a mentor here that works with one. But basically, I'll just say that they kind of serve as a platform for users to discover music, It also helps artists' work to be monetized. They are also act as administrators and applications and render application services. And then example of some dispute. So I don't know how many of us know blackface, but from 2009 to 2019, he had this, he was always making publication and doing call-outs as to how Two-Face had infringed his work and used African Queen, claiming he was the owner. Parties eventually settled um, at Lagos Multi-Door Courthouse. The terms were not disclosed, so which is like the benefit of exploring alternative dispute resolution mechanisms such as mediation. So for music dispute, I think mediation would be your best approach. Negotiation first, if you don't have a contract. If you have a contract and you're drafting a dispute resolution clause, it's important that you draft a multi-layered dispute resolution clause that clearly states out the mode of resolving a dispute. So negotiation, mediation, and it also has to be time bound. Arbitration, like I tell people, is used for huge commercial transaction. For instance, say a music record label company is going to a merger with another. That's an example. So you have to include a multi-layered disposition clause with arbitration or a hybrid multi-layered of options. So you mediate first. If mediation fails, you then go to arbitration. But if you do not have a dispute resolution clause, remember you can always submit to mediation proceedings or arbitration proceedings. And the new Arbitration and Mediation Act 2023 is your guide. So I'm not focusing more on that, but there you also have structure within the recording company. So your partnership. So I think Lagos State is the only state that has a partnership law in Nigeria at the moment. However, CAMA makes provisions for the types of company that can be registered. So that can and should be your guide. Then lack of documentation to show ownership of rights in the song or sound recording can lead to negotiation breakdown where so you have an investor or a potential buyer coming to buy your catalog or something. Then copyright infringement over similarity of the melody and chord progressions, e.g. you have famous Let's Get It On, Bloodlines, then there's the Danny Young dispute with Tiwa Savage, like, can't remember, but that was like 5 years ago, I guess, where the song had to be taken down. I think recently you have the Davido song that he was featured on Oluchi or something like that was taken down. Then you also have trademark issues as to name. So there was this dispute in 2020 where, oh, do I still continue?
Yes, ma, you can continue.
Okay. Name of a band, name of the artist, stage names, and all of those things. They have issues as to unauthorized use of one's image. So recall when Cynthia Morgan was going on stating that she didn't have right to her name and she can't use certain elements regarding her entertainment personality. So you need to look out for such dispute that may arise where if you assign your image right and publicity rights, your trademark to a record label company, and some other person uses your artist's name or image in a way that is not in line with your business, you have to take necessary measures such as issuing a cease and desist. If the person fails to do that, you might. I think for such disputes, the court is your best bet. So we have precedent within Nigeria, and I think I like to draw our attention to the Kiss Daniel and the Kiss Daniel trademark issues. Not sure how that has been settled because I haven't really followed up on that. Then breach of contract. Artists breaching contract, producers breaching contracts, breach of NDAs where you have multiple collaborations of very high extent artist. So you're told, oh, you can't put out a publication stating that you're being featured or being contacted to feature on this album. For instance, when Beyonce came out with the what's the album now that Yemi Alade was featured on, something of that nature. If you breach those terms, the enforcement will definitely and immediately be triggered. Then you also have non-compliance with tax and immigration requirements, cross-border disputes. So the Shatawale and Drake's instance over unauthorized use of a song is a clear example. Rounding up now, streams of income, you have producers points, mechanical licensing, print music sync, performance, brand sponsorship, um, advance, merch, other ways that an artist can actually generate revenue. Publishing advances is another way. So, in all, if you're delving into the music business sector, it's very important that you understand the legal framework, understand what your artist or songwriter wants you to do in terms of representation, and also the producer as well. But whichever side you're sitting on, ensure that you have your client's best interest at heart, and also attend entertainment related events, read, write, collaborate, and that's my pitch for you guys. Thank you.
Thank you very much, Ma, for this enlightening session. And we'll be going to our second mentor right now. I know some of us may have questions, but please, I'll ask that you write your questions down so that after the mentors are done with their lessons, you can ask your questions because the mentor may answer something, the question that you already have now. So please, our next mentor is Mr. Tope Salami. Good evening, sir.
Hi. Hello. Hello.
Yeah, we
Can
can
you
hear
guys
you,
hear
sir.
me?
Good evening, sir.
Oh,
Yes,
sorry,
we can,
sorry.
sir.
Network went off, and I didn't even know I was to speak. Good evening, everyone. I'm trying to put on the video. Okay. Sorry, I'm trying to put on the video. Hi, good evening, everyone. Please, how many minutes do I have? My network went out the other time.
So you have like 15 minutes.
15.
Yes, but you can also take like 20 minutes just to enable
No. I can't even take 20 minutes. I think I will take 10 minutes. Because
Sir.
you guys already ate into my time. Yeah, so I'll be very brief and I'll be very practical, meaning that what I'm going to talk about today might be things you might not find in your books, but definitely things you would have come across, or things you might have heard, and things you would definitely come across, things that will be very handy. The topic is music, business, and law. Am I right? And I really don't think I need to explain the law. I really don't think I need to explain business as well. I don't think I need to explain music. But then when we say music business, what we're trying to say is just to bring the element of profit and loss into music. And when I say the element of profit and loss, the element of profit and loss means business, meaning for you to establish something with the aim of, making returns from whatever it is that you must have established. And that is the difference between running a business and running a charity. I mean, these are two different things. And of course, there's no way you want to run a business, or there's no way you want to run music business without, making use of, different legal machineries. And the best machineries you can actually make use of would be the special set of people known as the creative lawyers, IP lawyers, music lawyers, entertainment lawyers at large. So now, in trying to go into the music business, what are those things you need to, you need to put in place? What are those things you need to consider? The first thing you need to consider would be the territory where you want to run this music business. And when I say territory, where exactly do you want to start it? Are you starting in Nigeria? Are you registering a company in Nigeria? Do you want to start your business in the UK? Or you want to start your business in Europe? You want to start in America? Your territory would determine different things. Yeah, your territory can determine the kind of structure you put in place. Your territory can also determine the kind of music business you even go into. Most people right now, when you see them go into music business, they're probably going into music business because of Afrobeats. And I tell them, why must you go into business because of Afrobeats? You just say, Afrobeat is the biggest thing in town right now. And I would say, says who? Have you heard of the Brazilian funk? They have the Brazilian funk and they have the Brazilian folk music. Have you heard of either of both? Have you heard of both? Have you heard of so many classes or genre of music and or type of sound? Meaning, you as someone that wants to start business, you must have a vision, you must know what you want to do. I'm not saying doing Afrobeats is not fine. I'm not saying doing Afrobeats is not, it's not pleasing to, the ear. But then, in some cases, you might as well not want to do what other people are doing. You might as well not want to do the normal thing, depending on your jurisdiction, depending on your territory. Because 10 years ago, 20 years ago, we had reggae. Shampo was almost everywhere. More than 20 years ago, we still had reggae. I'm not saying we still do not have reggae. But reggae was doing what Afrobeat is doing today. Coupled with the fact that reggae was not even abused. The question is, where is reggae today? Yeah, people are still doing reggae. But the reggae of 20 years ago, where reggae was 30 years ago, is not where it is today. Unfortunately, some of us are actually fans of, the reggae music. Now, as a business owner, as a music business owner, I'm not going to say, so you can be an artist and also, be the owner of your business. But the music business owner, some special people they are mandatory. They are not needed. They are mandatory. You must get them. If you don't get them, when you go outside, they will flog you. When you come back to say, it is time to get these people, then you will pay times 2 or times 3 of what you should have used to get them earlier. The first one is you need a lawyer with an expert in this field. Then you need, depending on whether or not the business owner is an expert. If the business owner is not an expert, then you need someone who can manage your business for you. That would definitely be an expert and not a JJC in this field. And when I say an expert, someone who is experienced in label operations, someone who is experienced in A&R, someone who has good business goodwill in the industry. Aside from you having a goodwill in the industry, you must also have a good business goodwill, like a good business goodwill in this industry. Because if you do not, then along the line, you still chop the cane. And when I say chop the cane, I'm sure Mandy, a respected member of the bar, would definitely understand what I mean by that. So let's push forward. Aside from you having a manager who is, an expert in all these things, the manager will now have to create various departments and put experts in these departments, because the manager is just one person. Trust me, the manager cannot be in two places at the same time. The same way it might be difficult for the manager to handle more than one or two departments at the same time. Now, let's assume the owner of the business is even an expert in this field. In most cases, the owners of businesses are never around. Owners of businesses are always on the move, meaning that when you are absent as the owner of that particular business, you must get someone that can run the business for you while you chase money. These people that will run your business for you will create what we call the proper enabling structure. The Maven structure, the Chocolate City structure, and other structures in well-organized places where music business are being done. I'm sure we have companies that come out to say they are doing music business, but you and I, we all know those who are properly, who are doing the business properly. One of the take home you need to make sure you ensure will be the ownership of your craft. So if you are the artist, if you are good enough, and if you have a good team to help negotiate the ownership or a good level of control of your craft, that is beautiful. Some of us, we've done it in various cases where, artists were not meant to own, but at least they had to own. And that is what I say when I was making mention of, when I was making mention of having experienced industry experts. Some people will not be experienced and they'll be like, we can do this, we can do that. And by the time you throw one or two bits to them, you see them hugging the two bits, say, yes, we're going to do this, we're going to do that. By the time we throw one or two bits, we already know, this person at JJC, but if you talk to at JJC. So let us just push it forward. Now, it is very important for you to have a business developer or a business development person, a music business development person, because at the end of the day, you as the business owner, you are putting money into this. The question is, how do you want to get the money back? You have an artist. Yes, the artist is solid. The artist has good music. It is possible for someone to be as good as Angel Gabriel. Yes, to be as good as Angel Gabriel, to be the best lyricist, the best songwriter, the best vocalist, in terms of production, the best producer, all in one as an artist. And you would have somebody that has money, like CBN. Both of you will come together, or you as the creative might even have that money as CBN. You come together, you spend that money, and at the end of the day, you might achieve nothing. don't get me wrong, money is important, but you must know how to spend the money to do what? To gain your proper traction. When people, I mean, 10 years ago, I guess, 10 or 9 years ago, thereabouts, 10, 9 or 11 years ago, when people were saying, stuffs about Davido, I said something. I said, no, sometimes your father will have that money. Your father will spend that money on you, yeah? Or you might have that money, you might spend that money, and at the end of the day, nothing will happen. So let us give credit to those that haven't spent money and something happened. That is usually my own analogy. Now, when we say a business developer, sorry, please give me a few minutes. Sorry, I need to share. Sorry. Thank you. So I'm back. Sorry. So when we say, oh, someone that understands the business, yes, you've gotten someone that understands the industry. You've gotten people that understand the industry. Now, people that understand the business, they'll tell you, oh, okay, who are your publishers? Have you gotten that part sorted? Who is distributing for you? Are they third-party distributors? Are they front end or back end distributors? Or are you distributing through platforms like TuneCore? Or what exactly are you using to distribute? That is very important because distribution in this age is the fastest way your music can travel. Your sound can travel beyond places you might, your sound can travel to places you might never even go to till the world comes to an end. Sadly, I mean, there is this unusual growth of Afrobeat in Paraguay. I don't think I've ever seen any African artist, not even Nigerian artist, kill any show in Paraguay. And whether we like it or not, it will get there one day. We'll all get there one day. It's a moving trend. Yeah. Now, there are various ways. The earlier speaker had, spoken about a part of publishing. We have neighboring rights, usually taken care by the likes of Sound Exchange, PPL in UK, and co. We have independent publishers who, some of them have come in with big bags, and some of them, instead of giving you big bags, they would rather tell you, let us make sure we firm up your catalog in such a way that you would enjoy proper monetization. Music business monetization is the center point of it, and that is why they call it music business. Because at the end of the day, if you are not making that money, the business will definitely shut down. I will send my slides. I will send the right thing to our people. And part of the when it comes to publishing, we've got the likes of BMI, we've got the likes of SASEM, we've got the likes of ASCAP, we've got the likes of PRS. Things are getting better right now because Africans, Nigerians are, spreading, and our people too are climbing the ladder. Very soon, I'm sure things, will get better than we have it right now. And music business, the development of law will definitely be something everyone will be proud of. Hopefully, the new leadership of MBA would do more, because from our side, that's always been more of talk. Then when it comes to acting, we are probably never there when it comes to acting. And then for those who are acting, how effective are their actions? We hope everything gets better one day. And of course, for those of us who are in this field, respect to the earlier speaker and respect to Mandy as well. We hope we all get it right. And we hope we show the world why we are here. And we hope we show the world, or we give reasons to the world to actually, believe more in the industry, put their weight behind the industry, and do the needful for the industry. Thank you very much, guys. I might have to go log out like for like 5-10 minutes. Then I come on again, please. So the third speaker can definitely commence, but I have another class for 7 o'clock. Thank you.
Thank you very much, sir.
Yeah.
Thank you very much, sir. Okay, so now we'll be moving on to the mentees presentation, and there are 2 groups. So please, the presenter for group 1, are you ready? And for the mentees, if you have any questions, you can start typing them in the chat box. So after your presentation, the mentor, can answer your questions, and by that time, Mr. Tope will also be back. So please, mentees, group 1, are you ready for your presentation? The presenter or the backup presenter, are you ready for the presentation?
Good evening, ma. Sorry, I was trying to get my network right. Good evening, everyone. I'm ready for the presentation. My name is Olubunmi Akpata. Sorry, can anyone hear me? How many minutes do we have?
Yes, you can hear you. Please, each group has 7 minutes. Try your best to keep to the 7 minutes. Thank you.
Thank you very much. Good evening, everyone. My name is Olubunmi Akpata, and I will be representing Group 1 in today's presentation on music, business, and law. In my presentation today, I will take you through
I'm sorry, do you have your slides?
Yes, I do, but just give me a minute. Let me do the screen sharing. We already appointed somebody from the group to do screen sharing while I present. That's why I did not.
Okay, but just give me share the slides so you can all follow along.
I'm sorry, ma. I'm trying to get the presentation slide. So.
All right. No problem. You can start the presentation. I will help you share your screen.
Can you hear me? Your presentation now, and then you share the slide.
Thank you very much. Yes, thank you very much. So I will be taking you guys through the introduction, music ownership, financing, and collective management organization for the music business. Basically, the music business encompasses the commercial aspects of music creation, that is the production, distribution, marketing, basically anything that deals with the flow of the business aspect from the production stage to the consumer stage. So to manage music business, you have to have clear understanding of the stakeholders that play crucial role on the music business, and these people include the copyright holders, the record labels, music publisher managers, industry organizations, and the people that manage the entire flow of how the profits and loss of music business flows. Now, going into music ownership. The music ownership is founded and guided by the Copyright Act. In case of Nigeria, we can find the music provision for music ownership in Section 29 of the Copyright Act. Basically, and the copyright provides a bundle of exclusive right to music creators, generally authors, as in the language of the law. So the right to distribute, translate, publish, broadcast, and all other bundles of rights. So in a song, in a music, we have to copyright vested in two aspects, which is the musical works and the sound recording. The musical works comprises of the composition, layout, and the grand work of the music. Then the sound recording is the performance of the music. So we also have different types of ownership, like the joint ownership. You can find that in section 29. Sorry, section 29 of the Copyright Act. We have ownership of record label, publishers ownership, artist ownership, and so on like that. So it is important to have a clear understanding who owns a song, the ownership to a song, to be able to manage and ensure fair compensation and control over that song. So moving on to music financing. Basically, adequate financing is like a blood flow to any business whatsoever. So in the music industry, ensuring funding or financing is very essential, which is why we have to identify various ways where music artists or industry professional can actually source for fraud. So examples of ways where music artists can source for fund are record label advance funding, grants and subsidiaries, crowdfunding, self-financing, private investment, sponsorship, and loans. So if all around this source funding, you might have to go into contract deals that ensure that you get fund from your partnership or anybody donating or giving you loan or sponsoring you. So when dealing with such financial deals or financing deals, you have to consider a lot of factors like fair compensation, creative control, contractual duration, and expectation on obligations when negotiating these deals. Then moving on to collective management. Collective management organization are the organization of the industry that manage and distribute the rights and royalties on behalf of music creators. They're also responsible for negotiating and granting and collecting royalties for the music usage on behalf of creators. You can see section 88 of the Copyright Act that makes comprehensive provision for collective management. And the examples of collective management organization that we have in the musical industry in Nigeria is the Musical Copyright Society of Nigeria, MSCN, and we also have the international SCMOs like HASCA, BMI, CISAC, and Sound Exchange. So in conclusion, the major essence of understanding the music business and the law guiding it is to ensure the protection of your clients and especially understanding and having a clear ownership to secure fair financing, to secure fair compensation and protection of IP protection of your clients, and also ensure fair financing strategies on behalf of your clients. And all these things, understanding the basis of all these things are very crucial to the success of the music business. Thank you for listening. That will be the end of our presentation.
Thank you very much for your presentation, and we'll be going to group 2 now. So the presenter for group 2, are you ready? The presenter or the backup presenter?
Yes, I'm ready.
Okay, please, your slides are ready. You can start, then he will also share your slides for you. The person appointed to share your slides can do that.
Okay. Good evening. My name is Olajumoke Jowu, and I'm the presenter for Group 2. we'll be speaking on music business and law. So I would like to, sorry. So basically, we're speaking about how music business relates to law, and I'd like to start with speaking about royalties and music business. So royalties are basically payments made to right holders like artists, songwriters, producers. We have different types of royalties in music. We have mechanical royalties, we have performance rights royalties, we have sync licenses. And when it comes to royalties, it actually depends on the type of agreement that the talent has with the record label. Because if a talent is under a record label, um, the talents could have signed an agreement saying that, oh, okay, this amount, this percentage of royalties is going to go to the record label. This percentage of royalties is going to go to the publisher. This percentage of royalties is going to go to the writer and things like that. Okay. So I'm going to move on to distribution in music business. Distribution is a very important part of music business because that's how the music gets heard, and the talent or the record label could work with different distributors to make sure that the music gets out there. Distributors could be like Amazon, Spotify, Apple Music. It could also be all these calls. Sorry, I don't really know how to explain it. Like all those ringtones when you make a call and they're like, oh, you hear maybe a song in the background. That's also another aspect of distribution. Then the Copyright 2022 provides the legal framework for a smooth distribution of music in Nigeria. Then I'll also be speaking about licensing in music business and law. So licensing is basically the transfer of an exclusive or non-exclusive rights, permitting them to reproduce, publish, make a translation or an adaptation. Basically, you are giving them the right to your creation. And licensing, I feel like as I'm talking about licensing, I feel like I should also bring up sampling. Sampling is very rampant in Nigeria, but from my research, there has not been any case that has actually gone to court about sampling. They always end up settling out of court. Sampling is when you take a part of someone's song, you make it very obvious that yes, you took. Oh my God.
I'm sorry, I cannot hear the presenter anymore. Is she still on the call? If she's not on the call, please, the backup presenter, you can continue from where she stopped till she rejoins.
For questions she had.
So please, can we have the backup presenter for group 2 or someone from the group come finish the presentation on behalf of the group? Seeing that the presenter seems to have some challenge with her network. So can we have someone from group 2 come up to finish the presentation on behalf of the group so that we can take feedbacks from our mentors? Okay. If we don't have anybody to step in on behalf of group 2, we'll kindly want to go over to our mentors to we're able to send the presentation to them prior to the class. So they were able to look at the presentation and they saw what we did collectively as the groups, at the different groups. So please, we would like to just hear from our mentors who are here with us on call. What are their takes from what the groups presented or the presentation that they made, and if there are knowledge gaps that they feel that the mentees should have some level of awareness in as regards the presentation that they made. So we'll be going over to firstly Miss Rita, if she has any feedback based off of the presentation that Group 1 and Group 2 put together.
Okay. Let's see. So, I mean, I do not know how the presentation was shared in terms of the outline that each group was supposed to um put out. But I guess for me, other than the topic, like I said, because of I also delve into the dispute resolution aspect of my practice. I kind of also want to look out for such when reviewing presentation, as that helps me get a better, like, know that I mean, it's one thing to talk about remedies and enforcement, but then I think most times IP enthusiasts are more focused on the litigation aspects of IP than the other available means of resolving music related disputes. But I'll say the group that presented first, I like their outline. I think maybe while presenting, since it's like a bulky document, it's just to go straight to the point and then also like give us one particular example in terms of referring to life cases or include that. I mean, I saw a couple of cases that were cited, but then in trying to do the presentation, I think that should have included. And I think also in relation to the collecting society, I'm only aware that MCSN is the authorized CMO in Nigeria. But I also stand to be corrected because we're all here to learn. For the second presentation, the formats, that's in terms of fonts and their justification, is just too congested. I think they should have done a bit more research in relation to their work. Also, the fact that the other team members are not here to also help them with their presentation is telling on the organization for today. But I think everyone on that group should have been more supportive in terms of ensuring that they all got it right. And then having to, yeah. So yeah, I think they're about. See, I'm seeing more than 7 is but only one person, and the rest are not willing to come up. But their presentation for me, if we were to score it over 5, it would be 2.5. While the first group will get a 4 from me. So, but available to answer questions, and I'll do my best to respond based on my knowledge and experience. Yes.
Okay, thank you very much, Ma. And we'll be going into the question and answer section right now. Our mentees have already sent some questions in, so I'll be reading them out. Okay, so the first question is: you've encountered instances where multiple songs share the same title, or where there are various versions of a particular song. How can one address these issues or find a solution?
Is that
For
for me?
example,
Any of the speakers can answer.
I'm sorry, Ma, could you repeat yourself?
I was asking if that was directed to me or any of the
Oh,
speakers.
yes, directed to you, Ma. Mr. Tope is not yet on the call anymore.
I thought Mandy was also supposed to present, or she's not on the call again. But
Yes, but this,
so your question is, why do we have several names in relation to musical works? First off, we need to, I mean, if you look at the Copyright Act, it clearly defines what should qualify as a copyrighted work. It must be original in a fixed and tangible format, irrespective of the title, irrespective of the quality, sorry. Then you have the musical work and sound recording. Now, it also goes further to list what cannot be copyrighted, and short phrases, titles, ideas do not enjoy copyright protection. However, because you're in the music industry space, there are always other alternative IP, such as trademark, that can be explored. Trademark will protect short phrases, your stage name, name of your band, um, and if you have a logo affiliated with your band, such as 30, the Davido 30 GB, I think it's 30 GB or 30 gang, whatever. And that's about that. Now you now have creations of music like derivative works. You also have the sampling, the interpolation, um, let me see, yeah. So all of those things are like the factors that you find within the music space. So it's easy for someone. So if you do like so I use Spotify more than any other, DSP out there or streaming platform out there to listen to my song. So if you type in All I Want for Christmas, you're going to see a Justin Bieber version, you're going to see an Ariana Grande version, you're going to see the most famous person's version, which is Mariah Carey, with different updates or different version. So a typical example again would be the Tracy Chapman performance during the Grammys with what's that guy's name? So the guy basically, so if you go on a musical live show, the live show will always get a blackhead license to cover participants that will cover a song. So you need to know that cover songs are not infringement. Where you infringe or you're alleged to be an infringer is where you start to monetize. And that was the issue that the two ladies had with Shonda Rhimes in relation to the musicals from the Bridgerton season 1. Do a cover with the consent of the owner of the song, as long as you're not monetizing it. But now you have instances where a transformative work, especially within the US, where they have, it's in their law, there's a definition for what a derivative work is. There's a definition for what a transformative work would qualify. So if you're in the US, like Mr. Tokwe had stated, you know what applies to your sector. But in Nigeria here, in as much as our copyright law has been updated and has done its best to cover instances that apply to us, musical titles, album titles cannot be copyrighted, but they can be trademarked. So if someone does a cover of your song, as long as it's not monetizing it, there's no issue. If the person decides to, like, maybe people now start to, so you find out sometimes that when someone does a cover, people tend to prefer the cover to the original song. Also, you find instances where that may now make people become aware of the original song. Oh, I like to know who originally sang the song. But then if you look at it from the corporate aspect, where someone's kind of like links a song to an owner acting as a source identifier, those are the potentials of a trademark name. I think bands like the Beatles had an issue with their title. I also think Prince had an issue with his title Purple. Um, all of those things. But then the Nigerian entertainment music space is still developing in terms of copyright awareness, IP awareness generally. So any information within I like to tell people that I feel the creative sector became more interested in IP because during the pandemic, you saw a lot of foreign artists who were still generating revenue from the use of their musical work or sound recording, which is why you also saw a lot of takedown notices that were issued to DJs that were playing songs um, or doing live performances during their Instagram live during the pandemic. What was the second part of your question again? I think it was in relation to the kind of licenses. So remember in my introduction, I had stated that the musical work or a song has a musical composition, which is the lyrics and melody. Then you have the sound recording, which is like the audio recording. Now you are required to get two sets of licenses: license for the use of the master recording and license for the use of the underlying composition. So if a musical work is to be adapted and used and synced in a film production or an advert, you now have to decide, am I going to get a license for the master recording or for the composition? It's very important that that is clearly stated. It is also important to state the term of use of that song. So I don't know how many of you are Stranger Things fans, but I think that's like a proper or good example of how music sync works. Um, what else again? I think that basically answered. Let me know the next part of the question that I did not answer.
Okay, thank you, Ma. I think you've answered like three questions in one.
Oh,
So
that's
thank
fine.
you for that. The next question will be, what are some common problems with music financing and how can they be mitigated?
I think for me, I have like a very diverse view from most practitioners. First, talking about music financing, is it music financing for an artist? If it's an artist, I always advise artists to consult, especially if you're upcoming. I mean, you should focus more on the DIYs and look for the low hanging fruit on how you can have a good bargaining power before going to accept any form of financing known as advance in the music space. You also have financing where record label companies or big international brand companies may want to buy out a publishing company or a distribution company and add to their portfolio. So they're going to take into several considerations, which is kind of like what checklist which you have to go through when you're going to a typical M&A. That's merger and acquisition within the sector. Is the person unencumbered? You have to do your search, do your investigation, be sure that all the catalogs that the person own is, within their purview, they own it. What is the worth of each catalog within their hands or their portfolio? You also need to look out for regulatory compliance requirement in relation to financing. So sometimes you find out that an artist can crowdfund. Can a record label crowdfund? That will depend on what the companies act within that jurisdiction, provide. Can they also float in terms of selling their shares and all that? So those are the things that I would say practically can be considered. I think also the was it Chocolate City conversation that came up last year when there was a publication that they're going to lose 50% of um I think it was their structure or something like that. But yeah, I mean the music industry is not different from other industry, but when it comes to the commercial aspect, where you have to sit down and sign deals, ensure that your boilerplate clauses are on point. Don't leave rooms for anyone to take advantage of you. If you're getting for artists who get advances, ensure that they also stick to their terms. I think there's a period when artists in Nigeria were breaking contracts despite the advance that they're giving. Ensure that you also advise the artist in question that when it comes to such, it's music business, it's not charity. So if someone gives you an advance of say 100,000 for publishing, or you get I think it was I can't remember. So I have an episode with a music marketer who talked about how they were offered a publishing or distribution deal that was so bad but the person that gave them the lower advance had better offer. So you need to look at what your artist wants at the end of the day, and if it's in line with their career goals. So yeah, I think that basically covers it for me. Anyway, that's how I say it.
Okay, thank you very much, Ma. Next question is, who owns the copyright to a musical work if a dispute arises amongst the composer, instrumentalist, and the lyricist?
So for IP disputes in relation to musical work or sound recording, first is you have to look at what the law provides. The law clearly states that the person who creates the work is seen as the author and owner of the work. Then he goes further to create the exception. In the event where a contract was signed, so a contract will always determine who owns it. So a record label company and an artist goes into an agreement. The record label will always own the musical work. However, in an event where there's no contract, the law will take precedence. When you have a contract, your contract is binding. You are bound by that contract. You also need to show and prove. I think I had reviewed this case about all the way up. Yeah. The person was paid upfront, paid I think it was $100,000 for his contribution to the song. And I don't think that this person actually expected the song to blow. And when he saw that the song blew, he came back later on to come and say, "Oh, I am entitled to the royalties that are coming out from streaming, the use, blah blah." And they're like, "No, you signed off on a napkin. We have that napkin to show that you signed this and you were paid X. So you can't come now because you see that the song is generated." So those are some of the music IP ownership in relation to sound or the music composition as one of the disputes you will basically encounter. I think there's one between Asha and a producer if that song has not been released. You also have instances where you've not cleared the song and then you go ahead to release it. The IP owner, the person who created the song, has the right to prevent you from further use. If it means them going to court to get an injunction to enforce that, they're going to do that because that is part of the bundle of exclusive right that the law grants them. So the law will always determine who owns the work in as much as you have the automatic protection, but the person who creates the work first is the owner of the work. Whatever happens after then is based on parties' agreement.
Okay, thank you, Ma. The last question I have here before the next is ask their live questions is, does music licensing transfer ownership?
In one word, no, because licensing is you basically giving someone the right to use some of your exclusive rights. So it could be a distribution. So you have the license to distribute this song within Nigeria and 3 other African regions for a term of 2 years. You have, okay, so licensing into 2 or 3. There's the self-licensing, there's the exclusive license, and then there's non-exclusive. The self-licensing is not popular, but the most common ones are the exclusive and non-exclusive. Exclusive means you're giving just one person the right to monetize your musical work, either to adapt it or translate it or reproduce it or distribute it or communicate it to the public. That's under Section 9. However, it's a bad deal when you sign an exclusive license because as an artist or as a creative or a producer or a songwriter or a composer, you are supposed to have like if you have a good IP strategy, you're supposed to have stream of revenues, different streams. So you're giving sync license to someone to adapt it into a theater musical. You're giving reproduction right to another person. You're also giving another person a sync license. So a non-exclusive license is more profitable because you can have different revenues coming in from you. However, what you see is that most creatives or artists do not even understand that with the bundle of exclusive rights that they have they have access to numerous stream of licensing. Ensure also that whatever license, whether it's exclusive or non-exclusive that you're opting for, it's a good deal. So you don't come out tomorrow to, start creating long Twitter threads and telling us the history of a relationship that we're not even privy to, you know. And then the terms and conditions of your licensing agreement would determine what happens. So I do recall that during the pandemic, when the conversation as to NFTs were being had, there was a misconception that when you license or you assign your rights, you are assigning all your bundle of rights. No, but that is a license or an assignment. You are never assigning all your bundle of rights, including the economic rights to monetize and your moral rights to prevent any form of mutilation or distortion of your musical work. But in the event where you license, you just have like a generic license agreement. Nobody knows whether it's exclusive or non-exclusive, and it says, "Oh, you are licensing all your musical rights as provided under the law for X to use for a term of 15 years." You're going to be bound by that. So for jurisdiction like the US, they have what is called a termination right. And I advise you guys to follow Mark Jaffe. He's been on my podcast twice. He's currently creating content in relation to music law in the US. The US has what is called a termination right. We do not have that under our law. The termination right will basically state that if I give you a license to use my copyrighted work, whether musical, um, sound recording, you can do that for a term of 35 years. After 35 years, all rights revert back to me. You can't come out tomorrow to say, oh, I know that, because I think, but this is not in relation to film. This is not in relation to music. This is in relation to film. The what's that movie now that Tom Cruise was in? An estate had given a film production company the right to adapt or create a movie out of the story of from a newspaper that was published years ago, and the 35th year ended elapsed during the pandemic. So they could not um, publish that movie, they could not distribute it, they could not even showcase it anywhere in the world because of the pandemic, because the agreement was it was going to be a theater release. And they go ahead to release that movie 2 years ago, and the heirs and successors entitled sued them. And the court came back to, I think it was in favor of the film company and not the estate. So, when it comes to music contract, it's important that you pay attention to whatever it is you're signing. You also have like a renegotiation clause that gives you the opportunity to actually come back to the table when you have like a bigger bargaining power and stuff like that. That I think that should answer the question, or that answers the question.
Thank you very much, Ma. So on to our mentees, please, if you have any other questions, please signify. So does any other person have any other question for our mentor? Okay, so that means we have come to the end of our session for today, and I want to really take out the time to thank our mentors for taking out the time from their busy schedules to come and speak to us about this topic today. I know that now any song I listen to, I also think about the intricacies and the things that went behind producing that song. And it's not just about listening to the song and laughing and dancing. There are also a lot of things that went behind does to make that song available for us. And then I want to also thank you for taking out the time to answer our questions and for your feedback. And for our mentees, I hope you understood everything that our mentors spoke about today. And thank you very much, ma. So we have come to the end of our session for today. I hope we'll see you all next week again. Thank you.
Thank you guys, and have a good evening, everyone.
Thank you, ma.
Good night, everyone.
Good night.
Thank you, ma. Good